Today, we are talking about the key points to understand about O'Connor applications. So if you're involved in a criminal proceeding as a witness or even the accused, well, you might be wondering what an O'Connor application is. I'm going to go through it today. I'm Natalie Gerry, the principal lawyer and founder with Gerry Law. I help injured people get the compensation they deserve for their injuries. So this is a bit of a different topic today. What are O'Connor applications? These refer to requests made by the accused in a criminal case to access personal records of the survivor witness who would be testifying against the accused, usually. So this would be for things like medical records, counseling, or social services records. And the purpose would be to introduce evidence about the survivor's sexual activity or history during the trial. The term O'Connor application comes from the 1995 Supreme Court of Canada case called R. and O'Connor, which established the procedures for such requests. So you might be wondering, why do these applications exist? So they exist because the right of the accused includes the ability to gather evidence relevant to their defense. However, the rights of the survivor witness to privacy and dignity are also protected under sections 276 and 278(3) of the Criminal Code. So the step-by-step process for the O'Connor application, I'm going to go through it here. Step 1 is that the accused submits a written application, or their lawyer more likely submits the application. The accused or their lawyer files an application with the judge, and this application must clearly describe the evidence that they want, for example, the records or information. It must also explain how the evidence is relevant to their defense. If the records are held by someone else, like a therapist or a doctor, the application must identify who has them. So for example, the accused might request medical records to argue that the injuries described by the survivor were caused by something else. Step 2 in the O'Connor process is notifying the survivor or witness. So the survivor must be informed immediately that the application has been made. The survivor then has the right to attend the hearing on the O'Connor application, and they have the right to be represented by a lawyer. If the application involves third-party records, the person or organization holding those records, so for example, a doctor or a therapist, must also be informed of the hearing and has the right to attend. Step 3, the hearing. So the judge holds a hearing to decide whether the requested evidence can be included in the trial. The key aspects of the hearing are, first of all, it is private, so no jury or public members are present. Secondly, a publication ban prevents the details from being shared publicly. Third, the survivor can choose to attend and to make submissions, but the survivor cannot be forced to testify. During this hearing, the judge will consider various factors. So the rights of the accused to present a full defense, that's one of the factors considered. Another factor is the privacy and dignity of the survivor. Another factor is whether the evidence is actually relevant to the case. So step 4 in the application is the judge's decision. After the hearing, the judge may allow all or part of the records as evidence to be disclosed to the accused. The judge may also deny the application entirely. The judge may also order the records to be reviewed privately by the judge before making a final decision. So the judge can review the records and see if they really are relevant before making that decision. If the judge orders that the records are disclosed, the survivor will be informed and a follow-up hearing may occur to determine whether the records can be used in the trial. You might be wondering at this point, what rights do survivors have? So first of all, survivors have the right to privacy and dignity. Canadian law recognizes the importance of protecting survivors' privacy, even as witnesses in a criminal case. Evidence about sexual history or personal records cannot be used unless it is directly relevant to the case. The next right that survivors have is to legal representation. Survivors have the right to hire their own lawyer for the O'Connor hearing, and this lawyer can argue against the use of the personal records or of irrelevant evidence. The lawyer can also protect the survivor's interests during the hearing. The survivor also has the right to choose whether to attend or not. Survivors can choose whether they want to go to the hearing and hear what is going on, or if they do not want to go, that is up to them. Attendance is not mandatory. I'm now going to go through some frequently asked questions about these types of applications. You might be wondering, why does the accused have these rights? So this is founded in the Canadian justice system because the Canadian justice system prioritizes a fair trial, which means the accused has the right to present a full defense. The second frequently asked question is, what happens if the judge approves the application? In this case, the survivor will be kept informed of each step. If you have questions, your lawyer or a victim services coordinator will provide updates and explanations. Another common question is whether mediation offers or disclosures are confidential. The answer to this is yes. Any offers or discussions during the O'Connor hearings are protected by settlement privilege, meaning they cannot be used later at the trial. So overall, understanding O'Connor applications can help survivors to feel more confident navigating the legal process. These applications are intended to balance the right of the accused with the survivor witness's right to privacy and dignity. If you're facing this process, working with a lawyer experienced in sexual assault cases is important to protect your rights and to ensure that you're supported at every step. If you have a sexual abuse matter, I can be contacted at the information below, and I would be happy to discuss your case with you and provide advice.